You are shocked. You are beside yourself. You are going out of your mind when you hear the jury come back with their verdict. And now, you hear the verdict, and what is it? Yes, they decide that your doctor was careless. And yes, his carelessness was a cause of your injury. But now, in the amount of money you are to receive, now they tell you you are entitled to receive zero. Zero. How is that possible? How could they come to that conclusion? Is that really possible? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, it is possible. But really, how is that possible? Well, you see, in order for the jury to reach a verdict, they have to answer a series of questions. And in a medical malpractice case, one of the very first questions they have to answer is, was your doctor careless? In other words, did he violate from the basic standards of medical care? If the answer is no, that's it. You go home without a dime. But if the jury turns around and says, you know what, we believe the doctor was careless, well, now they are required to go on and answer the second question. The second question, and that is, was his carelessness a cause of your injury? In law, we call that proximate cause. If the answer is no, that's it. There's no connection between the wrongdoing and your injury. There has to be that connection. And if there is no connection, there's a gap, which means your case is over and you get nothing. But that's not the scenario I described in the headline of this video. In this video, the headline is, listen, the jury has determined that yes, your doctor was careless. And yes, his carelessness was in fact a cause of your injury. So now, the next series of questions the jury has to answer is how much money you are to receive as a result of all the harms and losses and damages that you suffered because of your doctor's carelessness. And now the jury is evaluating each element of damages that you've claimed. You're claiming medical expenses. You are claiming lost earnings. You are claiming pain and the suffering you endured from the time of the wrongdoing up until the time of trial. And typically in New York, that's about a 2 or 3 year gap in time. And then from the time of trial into the foreseeable future for the remainder of your life. That could be 10, 20, 30 years. So now the jury comes back and says you are entitled to absolutely nothing. Is that possible? The answer is yes and no. Now, you might be wondering, what do I mean yes and no? Well, the reality is that the jury has the opportunity to go ahead and answer those questions as a collective, meaning 6 members of the community have come together to decide whether or not you are more likely right than wrong and whether or not you are entitled to a verdict in your favor. So now you've proven your case. You've shown that you're entitled to a verdict in your favor. But for whatever reason, the jury has now come to the conclusion that you are not to receive a dime. Does it make sense when you have testimony and evidence to support all of your injuries? Does it make sense that you're unable to do all of your activities and the jury learned all about that? Does it make sense that these injuries are going to be disabling and physically incapacitating so that now you won't be able to do those things that you normally used to be able to do? Does that make sense? Does it make sense that you won't be able to return to work for many, many years because of your injuries and that you're going to need ongoing medical care and treatment? Does it make sense that the jury gave you absolutely nothing? No, it doesn't make sense. But again, we don't know what the jury was thinking. We don't know what conclusions they reached. One of the first things that your attorney is going to do when he hears this verdict is he's going to jump up out of his seat and say, Your Honor, I ask that you poll the jury. Now, what does that mean? It means that he wants the judge to ask each and every juror, all 6 of the jurors, whether or not this represents their verdict. Yes or no. Why is that? Because there could be an error in transcribing the amount that they actually were going to give the patient. That's a possibility. So now he wants to make sure verbally, juror number 1, is that your verdict? Yes, it is. Juror number 2, number 3, number 4, all the way to juror number 6. They all agree, yes, that is our verdict. This patient is to get 0. Now that's a very interesting and unusual verdict because if there is testimony to establish that your injuries are significant and are permanent, it is almost impossible for the jury to come back and give you absolutely nothing. Plus, your attorney is then going to ask the judge to throw out that portion of the verdict as being inconsistent with the weight of the evidence and say, Judge, that makes no sense. I asked you to throw out this portion of the damages part of the verdict and now send us back for a new trial so we can go ahead and get a real jury who really understands the issues here and now decide how much money my injured patient, my injured client is going to receive in this particular case. You see, when the jury has determined that the doctor was careless and his carelessness caused harm and injury, now the jury is actually obligated to give you money as compensation for all of those injuries. So when they turn around and give you nothing, Not only is that inconsistent, but it's inconceivable, really, especially when you have such testimony to support all of the injuries and the damages you incurred. So why do I share this great information with you? I share it with you because in all likelihood you have questions or concerns about your matter. Well, if you're considering bringing a lawsuit and have not done so yet, and your matter did in fact happen here in New York, and you still have questions, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.